My name is Eric Sidoti. I'm the Director of the Whitlam Institute. And it's my great pleasure to welcome you all here. Before formally starting proceedings, can I, as is our custom, acknowledge the traditional owners of the lands on which we meet, the Darug people, whose lands, well, Auntie Norma can tell us as an elder of the Darug, the lands stretch from the rivers, really, isn't it? From the Nepean, the Georges and the Parramatta, and right up through these foothills into the mountains. It's an extraordinary bit of country that we are very fortunate that the Darug people have taken such care of for such a long period of time, of thousands of years. And I'd like to pay our respects to their elders past and present, and of course to acknowledge Auntie Norma for her presence here this evening. This evening is a great opportunity. It's a great opportunity for the Whitlam Institute to partner with the School of Law here at this wonderful young university. But the subject, of course, that we're dealing with tonight is a subject that goes, and I'm sure George will delve into this a little bit, but it goes to the heart not just of recognition but of identity, and indeed, I would suggest, of the future of our country and how we see ourselves as we forge a new future together. And there are few people, I'd suggest, who are as well credentialed as George Williams to offer this insight and to explore the question for us. I could go on for a long time about George's credentials. Foundation Professor, Foundation Director of the Gilbert and Tarbert School of Public Law, Anthony Mason Professor, which, given recent revelations about Anthony Mason in the life of Gough Whitlam, is a somewhat different proposition as it might have been 2 years ago, but a wonderful honour and a position he's held for some time now at the University of New South Wales. Australian Research Council Laureate, Fellow, author of 28 books, media commentator, and a great exponent of the public intellectual, a great exponent of helping people to understand the issues in a way that is elaborated and articulated from an informed position. So George is familiar to us in all those sorts of ways. In introducing him, and I think it's critical, particularly in this audience, because I know a number of you are studying here at the University of Western Sydney in law. One of the things that George exemplifies, I'd suggest, is not simply the capacity to be a scholar, but to be a scholar who actually steps into the community and has been willing to take his knowledge and skills and competence and bring it to bear, both as the public intellectual in articulating, but I'd also say as one who has advocated in the broader public sense for a number of people and issues, and explored it both directly through some of the High Court cases he's taken, and some of those have been remarkable, of course, as we all know, including the High Bridge, I think, was one of yours. And these are cases that have, in some respects, changed the country. And in his own career and public life, exemplifies that capacity to actually be a scholar, be a lawyer, be an advocate, and to offer the public a way to come to grips with the key issues of contemporary Australia. So it is my very, very great pleasure to introduce Professor George Williams.
Well, thank you, Eric. It's a great pleasure to be here, particularly after that fulsome and generous introduction. And I'd like also to begin by acknowledging the First Nations, and thank you, Auntie Norma, for coming to listen to me tonight. I appreciate that. And what I'm going to talk about tonight is a national debate that has only just begun in some senses in Australia, or at least it's about to thrust itself on the national stage after the coming election in a very significant way. That's because we're about to have a national vote to choose our parliament, but not long thereafter we're probably also going to have a referendum on voting to change our foundational legal document and to change it in a way that might, for the first time, positively recognise Aboriginal peoples in this country. Now, many people don't know much about this debate, and it seems to them that it's simply emerged in recent times without much of a backstory. It's a debate perhaps people think has just been thought up, perhaps on the run by some people, but it actually is a debate that goes back a long, long way. And what I'm going to do tonight is give you a sense of history in this area, because you can't understand, I think, why Aboriginal people in particular want this change without understanding the 112-year history of this nation since the Constitution came into force in 1901. But before I get to that, I just want to give you a bit of recent history, just to give you a sense of what's been happening in this area before I go back a bit further. The modern part of this debate about recognising Aboriginal peoples in the Constitution actually starts with John Howard in 1999. You might recall we voted on a republic in 1999, but there was also a second referendum question which also failed. That was the first attempt that Australia had to recognise Aboriginal peoples in the Constitution. It was to put a new preamble into the document, some opening words, and John Howard drafted those words after an abortive first attempt where he talked about mateship in those words. He came up with a form of words that honoured Aboriginal and Torres Strait Islanders, the nation's first peoples, and recognised their kinship with their lands, their ancient and continuing cultures, which enriched the life of our country. So those were words that sought in a positive way to fill this recognition gap. But that referendum failed, and for many people they were simply even unaware that there was a second question before they got to the ballot box. The next step was again John Howard in 2007. In the shadow of that election, he announced just before he was voted out by the Australian people that he would put a second referendum on this topic, again in the form of a preamble. So it was going to be Australia's second attempt at this, but of course he lost that election, and so that referendum did not occur. In the interim though, several states have moved in their constitutions to recognise Aboriginal peoples. Victoria was first, and now Queensland, New South Wales and South Australia have all recognised Aboriginal peoples in their state constitutions. One of Kevin Rudd's first acts as Prime Minister after the 2007 election was of course the important apology. In that, to quote his words, he said there will be constitutional recognition of the first Australians, and he promised a process, a referendum on this at some point. The hung parliament produced by the 2010 election kicked the debate on a bit further. Prime Minister Julia Gillard agreed with the Greens and independent members that there would be a referendum on this topic during the life of the current parliament. That commitment was dropped though when it became clear that not enough work had been done to inform the community and actually build support for the change. What the government did do though was set up an expert panel which travelled the length and the breadth of the country to ask Australians what they wanted to see, and what that panel did was come up with text to change the Constitution, and also found through polling and the like very strong community support for taking this step. The government has also funded during this term Reconciliation Australia to do a lot of grassroots work, and the recognised body has been created. It's got a great website to give you information on these issues, to inform Australians and to generate support. And I know some recognised people are here tonight, and there's information that will be available after this talk if you'd like to know more. If you do want to get involved in this debate, the recognised body is the right way of doing it. It provides you a great way of getting involved, access to materials, and also a way of getting involved in your community. So where are we right now on this debate? Well, as we enter the final stage of this very long, it seems, election campaign, we have promises from both sides of politics that we can expect a referendum in the next term of Parliament. Tony Abbott has said, including at Garma just a week or so ago, that if he becomes Prime Minister, he will within a year release the model for the referendum, with the referendum he thinks to be held shortly after. Kevin Rudd has said that the referendum will be held within 2 years if he is re-elected. Either way, whoever wins the election, we can expect with quite a good degree of likelihood that we will be holding this referendum, most likely in the first half to the middle of 2015. So we're about 18 months to 2 years away from the referendum, but I think it's clear, given the lead-up, and it's quite a substantial lead-up over the period of 14 years, that we're about to get to the business end of this debate. We will be talking about models, proposals and ideas with a view to holding that national vote, which, like the 1967 referendum, which I'll come back to, was a very important moment of nation building in Australia's history. Well, there's been a lot of effort to get to this point, where it looks like we will be holding this referendum. Many steps, a failed referendum and bipartisan support. And a lot of people wonder though, why all the effort? Why is it that both sides of politics have identified this issue as being important? Given that there is so much that needs to be done in the area of Aboriginal policy and redressing disadvantage, why focus on this old legal document, the Australian Constitution? Something which surely people think has little or no connection to our lives today. And certainly if you read the document, you'd be hard-pressed to see why it matters, why Aboriginal people have fought for this change. Lionel Murphy, for example, an Attorney General in the Whitlam government and subsequently a High Court judge, used to say that he always kept a copy of the Constitution by his bedside, and he was someone who occasionally got insomnia. He never found a better cure for insomnia than reading the Australian Constitution late at night. And I challenge you, if you can't sleep tonight, I guarantee you won't get past section 24 before you nod off. So what's this old arcane document that's hard to read got to do with this debate, and why have Aboriginal people themselves, and it's important to recognise this is on the agenda because Aboriginal leaders and communities want it there. Why are they putting it there? Well, the short answer is that the Constitution does fundamental things in our community that mean that for Aboriginal people, the Constitution is one piece in that jigsaw puzzle that needs to be put together to address disadvantage and to improve their lives and also our nation in quite a fundamental way. It's because, firstly, the Constitution is ultimately responsible for establishing lines of power in our society. It establishes who can do what to whom and when. And if you think of the position of Aboriginal people and the laws that have been passed in areas like stolen generations, stolen wages, controlling who Aboriginal people can marry, where they can live, the question of power and who can do what to Aboriginal people is absolutely fundamental within our community. The question of who can do what when it comes to Aboriginal people is absolutely fundamental. So naturally you turn to the supreme law, the Constitution, in order to look again at that issue. The second thing the Constitution does is it establishes relationships and legitimacy within our nation. The absence of Aboriginal people from that document and the apparent notion that our history only begins in 1788 has a very important role in terms of establishing the legitimacy, the cultural importance of Aboriginal histories, their place within our communities. It's something that has a flow-on effect into education. And if you look, for example, at the impact of the preamble in the United States Constitution within their education system, you get a strong sense of the potential of a document of this kind to influence people and to educate them about our system of government. And I must say, for me, this question of legitimacy in education is one of the most important reasons I support this change. I've got a 7-year-old son who's in year 1 in primary school, and I want him to learn about Aboriginal culture and about our system of government, and the Constitution is the natural way that normally happens. Wouldn't it be a good idea to have a Constitution that properly reflected Aboriginal histories and cultures in a positive way that would actually play out in that setting, rather than a document that is written as if Aboriginal people simply don't exist and have no part in our community? And the third thing the Constitution does is it provides recognition and establishes national aspirations. It, if you like, is part of the setting of goals within our community by establishing what's important, what are the things we should be striving for, and preambles, the opening words to these documents, are often articulated and used in those ways. So when you look at a document that fundamentally establishes lines of power, legitimacy and national aspirations, it's no surprise that Aboriginal people have identified their omission from that document as being important and have traced that back to some of the problems, some of the grassroots problems that they suffer from. What you have also in these cases is not just a document that's silent, but also a document that's actually premised upon discrimination. So a document that's actually sought to write them out of our history is even more insidious in its impact than a document that simply says nothing. It's in this regard that the importance has been recognised much more broadly by professionals in a range of areas when it comes, for example, to health. It's been recognised by researchers looking at the social determinants of health, that things like exclusion, omission from your own community, is something that can have a very significant effect upon your mental and physical health. Here, for example, is what the Royal Australian and New Zealand College of Psychiatrists said in regard to constitutional recognition to the expert panel that looked at this issue. They said the lack of acknowledgement of a people's existence in a country's constitution has a major impact on their sense of identity and value within the community and perpetuates discrimination and prejudice, which further erodes the hope of Indigenous peoples. There is an association with socio-economic disadvantage and subsequent higher rates of mental illness, physical illness and incarceration. Recognition in the Constitution would have a positive effect on the self-esteem of Indigenous Australians and reinforce their pride in their culture and history. It would make a real difference to the lives of Indigenous Australians, and it is an important step to support and improve the lives and mental health of Indigenous Australians. So there's just one perspective from that Royal College of Psychiatrists as to why changing this old document, the Constitution, matters, or more fundamentally, why it's actually time to overcome discrimination within the document and to write Aboriginal peoples into a foundational document in a way that is appropriate and long overdue. Well, what I want to do now, hopefully having given you a sense as to why this is on the agenda and why Aboriginal people have fought for this for such a long period of time, is to go back a bit further and to give you a sense of the Constitution as it was drafted in 1901, because it's only with the benefit of that you can really understand why this debate goes back as far as it does. We got a Constitution in 1901 after a decade of drafting, and Aboriginal people were not consulted. They did not form part of the conventions that drafted the Constitution, and they played no meaningful role in the document that we ultimately got that forged the Australian nation. Moreover, the Constitution was drafted against the values of the time, and of course those values by today's standards were undoubtedly racist. The standards at the time meant it was appropriate to treat people differently because of the colour of their skin, and we had a variety of provisions in our Constitution that reflected that racism, particularly when it came to Aboriginal people. What we got was a Constitution that was drafted in order to exclude Aboriginal people, and it's quite express on the face of the Constitution. And that was done in such a way that Aboriginal people in 1901 in their own lands couldn't even be called second-class citizens. That would be putting it too high. They were not conceived of citizens in any way. They were seen as people, to use the language of the time, who were a dying race. And indeed the Constitution was drafted with the view that Aboriginal people probably would not exist in Australia at this point in time. The framers looked to what had happened in Tasmania, for example, where they thought a genocide had occurred, and believed that that would be replicated throughout the mainland. And there are many references to this in the convention debates, that we needed a Constitution that was premised on the idea that Aboriginal people, being a dying race, were not needed to be reflected in a positive way in the Constitution over the longer time. This history is reflected in the express words of the Constitution. One clause, section 25, says, for example, that the states can disqualify any person from voting in their elections on account of race. That provision is still in the Constitution today. It's headed races disqualified from voting. Another provision, section 51(26), enables the Commonwealth Parliament to make laws for the people of any race for whom it deems necessary to make special laws. Both of those clauses are there to enable forms of racial discrimination. Section 127 went a bit further again in saying that in reckoning the numbers of the people of Australia, and I quote, Aboriginal natives shall not be counted. And the reason Aboriginal peoples were not to be counted was firstly they were not to be given the vote, so there's no point counting them. And secondly, as a dying race, even then they had some standards, and they thought it would be a bit shameful to count people as they dwindled. And so it was thought not appropriate to keep statistics about what was likely they thought to happen. The racist power in particular that I've mentioned was put there because it was thought, and to use the words of our first Prime Minister, necessary to have a power to let the Commonwealth regulate the affairs of the coloured and inferior races who are in the Commonwealth. And it was thought appropriate that the Commonwealth have a power to ensure that people who are not white could not live in areas reserved for white peoples, could not hold jobs reserved for white peoples, and in particular those laws were to be directed at Chinese people on the goldfields, in the laundries and elsewhere. It was not a power at that point that could have been directed to Aboriginal people. They were actually excluded from that power because it was thought that discrimination against them was something that would be dealt with instead by the states. But nonetheless, we got a racist power that was overtly directed at racial discrimination. Now that's how the Constitution was drafted in 1901, and that's something that was very quickly reflected in the law and the policy of the new Commonwealth, not just in policies that came down the tracks like stolen generations and the like, but the White Australia policy, one of the first laws enacted by the Federal Parliament in 1901. We also had the Commonwealth Franchise Act in 1902, which in some respects for its time was a world leader in giving women the vote, very early back then. But at the same time that the Australian nation gave women the vote nationally, it denied that vote universally to Aboriginal people. And it gave you a sense of both our progressive nature, but also our unwillingness to give the vote to Aboriginal Australians. We also had more recently, to show how these types of laws have never quite left our statute book, more recently on a few occasions we've had a willingness by the Commonwealth Parliament to expressly enable laws that are racially discriminatory by overriding the Racial Discrimination Act. Hence, for example, we had with native title an overriding of that act, and more recently in 2007 with the Northern Territory Intervention, a law that says, to the extent that this law is racially discriminatory, it shall operate to that effect, notwithstanding any provision in the Racial Discrimination Act. So these are things that this legacy of race is something that continues up to the present day. Now, many Australians think that these issues were fixed in 1967 when we did hold a referendum dealing with Aboriginal peoples. And certainly by that time, Aboriginal peoples had been given the vote in national elections, though not on the same basis as other Australians. It was not compulsory for Aboriginal people to vote, unlike other Australians. That did not occur until 1983. What we did have in 1967 was a referendum directed towards removing the discrimination from the Constitution, but it only did the job in an incomplete way. What that referendum did is delete the provision that said you can't count Aboriginal people. So for the first time, Aboriginal people could be counted in the census in their own lands. What it also did was extend this racist power to Aboriginal people for the first time. So a power designed to enable non-white people to be prevented from having certain jobs was extended to Aboriginal people in a way that could be either used for their benefit or their detriment. And nothing was put in the Constitution to make it clear that the racist power should only be used to advantage Aboriginal people, and so hence the drafting ideas that this was there as a discriminatory power equally extended to Aboriginal people. What the change did more broadly was it knocked out these negative references to Aboriginal people, didn't knock out the references to race, such as the section that still recognises that states can stop people voting because of their race, and put nothing that in any way positive recognises Aboriginal peoples. It knocked out some negatives, kept the racially discriminatory stuff, and didn't mention Aboriginal people in the bargain. And it's why for many people they think there's unfinished business out of this referendum that still needs to be tackled. More broadly, it left Australia in 1967 until the present day with, as far as I'm aware, the only constitution in a democracy today that still recognises that people can be treated differently because of their race in a negative way, that still recognises that racial discrimination is a possible constitutionally sound policy of the nation's fundamental legal document. South Africa and other nations got rid of these clauses a long time ago. We're the only one, as far as I'm aware, that has, for example, that clause that says race is disqualified from voting still in it. And for me, it's somewhat a matter of shame, I think, that as a community we've never actually got around to removing a clause of that kind. Now, lest there any doubt about that, I saw this firsthand as a barrister in the Hindmarsh Island Bridge case, just how these clauses are still relevant and important to the present day, that the history is something that speaks directly to the content of Australian law. The Hindmarsh Island Bridge case, some of you will recall, was about secret women's business and the attempt to prevent the development of a bridge that affected the areas of significance to the Namangiri women. They brought a case in the High Court seeking to have legislation struck down that specifically targeted them and said to the extent that the sacred sites legislation operates, it does not apply in their area. They are explicitly excluded from the protection of that law in order to enable the development to go ahead. Now, our legal team, with myself and people like Jim Spiegelman, argued that surely in this day and age the racist power shouldn't be seen as this negative power, to use the words of Edmund Barton, directed at the inferior races within the Commonwealth. Surely the 1967 referendum had been a turning point, and today the court should look at it differently. The Commonwealth took a different submission. Its Solicitor General Gavin Griffith argued that the power, and I quote, is infused with the power of adverse operation. He said, he acknowledged, and I quote, the direct racist content of this power, and said that that enabled the Commonwealth to pass whatever laws it wished on the topic of race, whether they be positive or negative. Michael Kirby on the court interrupted the Commonwealth at one point and said, does this mean that Australia could enact Nazi race laws? that simply targeted people because of their race, and the Commonwealth said, well, there's nothing in the racist power that would prevent it. And of course, that's exactly the sort of thing that the power was directed at. In the absence of a Bill of Rights or other protections, the Commonwealth said there's simply nothing to hold the Commonwealth back, except, of course, you would hope the good sense of our elected representatives. Now, in the end, the High Court left open the possibility that the power can still be used in this negative way. They did not accept our submissions, and the legislation was upheld. And to this day, as the Chief Justice of the High Court has said in recent years, we have a power which still enables laws to be passed against any race, but particularly Aboriginal people, that fix upon them because of the colour of their skin, that might prevent them having certain employment, take their lands, or otherwise treat them differently. Well, that, if you like, is the excursion into the history on the Constitution, and gives you a sense, I hope, as to why Aboriginal people see this as important. It's important to them because we have a Constitution that recognises they can be denied the vote, a Constitution that says they can be treated differently because of their race, and a Constitution that has actually been used, including in the Northern Territory intervention, to pass laws that explicitly recognise that such laws can be racially discriminatory. All of these things can be traced back to the Constitution, and if we actually want to deal with the problem of racism as it exists within Australian law, you ultimately have to go to the source. You have to deal with the authorising instrument, that being the Constitution, and deal with it in a way that both provides for recognition but also deals with the clauses that go back to 1901. And that's because the view of the High Court is it's not their job to fix these clauses. The Constitution says the people have the power to change it, and until the people decide to do so, in the Hindmarsh Island Bridge case or other litigation, the High Court will continue to proceed on the basis that the intentions of the framers back in 1901 hold true today, and that we should be taken to acquiesce and assume that those intentions are correct. Unless we make a change, we're simply accepting that we are prepared to go along with clauses that still recognise the denial of the vote on the basis of race. Well, what do we need today in light of that history? It's coalesced into a number of things that need to be done to the Constitution. The first is we actually need some positive recognition of Aboriginal peoples. And in this regard, you can look to democracies around the world with Aboriginal and Indigenous peoples to see that in their constitutions, it is a standard, normal thing to recognise the long history of a nation, including that of the Indigenous peoples. So we need positive recognition that can be used in education, that can provide legitimacy, and finally, to actually undo some wrongs of the past by actually providing appropriate words in this document in that form. But those words would only be symbolic. And if we just provide recognition, at least in my view, it would ring hollow to recognise in a positive way Aboriginal people while maintaining the power to discriminate against them is, I think, something that surely is not what we should be aiming for in this area. Hence, we also need to delete Section 25, the voting power. We also need to delete the racist power. And more broadly, I don't think we should have a constitution that in any way is conditioned on the idea that it's acceptable to pass laws based upon race. If nothing else, this whole idea of race goes back to the 19th century and the notion that you can measure a person's skull in order to determine their intelligence. I mean, that's the science of the time that feeds into our old constitution. And the whole idea of dividing people according to their race, well, if nothing else, it's missed something called genetics that has been worked out in the interim, along with a range of other scientific theories. So the idea of dividing people according to race should go, and it's something that I see. I mean, one thing that influences me is when I teach this area, I often have students coming up to me at the end of the class saying, well, we've done the racist power, but I'm really worried as to where I fit in. What race am I? My father is Indian, my mother comes from China, whatever it may be, what race am I? And unless you want to get into the old distinctions of quadroons, half-castes, and that's the language that it drives you to, you've got to discard the notion entirely as one that's inappropriate for Australia. Having deleted those provisions, though you can't stop there, you've got to put a power into the Constitution so the Commonwealth still can pass laws for Aboriginal peoples, even if it's not one based solely based upon race. That's because if you just take the power away, you knock out the negative, but you also knock out some positive laws that have been passed, the Native Title Act, sacred sites legislation and the like. And that's why there should be a power to enable the Commonwealth to continue to make laws for Aboriginal and Torres Strait Islanders. not as, if you like, a race, but as the nation's First Nations and First Peoples. That should also be limited by an express clause that says in passing laws under that power or any other power, the Commonwealth nor the states should be able to discriminate, should not be able to discriminate on the basis of race. And that would, for the first time, put in our Constitution a prohibition on using race in that way, something that is stock standard in modern constitutions around the world. And if we really want to make a break from the history on this, to move beyond racially discriminatory policies, I think we need to move beyond simply saying, let's delete the race, to actually saying we recognise it's a wrong turning, and future parliaments should not be able to go down that path. Now, the government's expert panel, which included people from all sides of politics, experts, Aboriginal leaders, came up with a list essentially the same as the list that I've given you, as to what needs to be done to change the Constitution. And indeed, experts in the field have generally agreed that these are the things we need to look at doing. Recognition, deleting the nasty clauses, and putting in a new power limited by the ability not to discriminate on the basis of race. As to how to actually achieve this, though, is not easy. I mean, that's the words we need, but there's a lot of work that has to be done politically and at the community level. And if you look at how to actually bring it about, it goes back to the fact that we do need a referendum on this. It's not something that Parliament can do. There has to be a national vote on this issue. That's because the Constitution says to bring about this change, you've got to first get it through Parliament, and then you've got to get it through the people. And by getting it through the people, you need both a national yes vote and a majority of states voting yes. So if Tasmania, South Australia and Queensland vote no, it's over, even if you've got 60% otherwise of the Australian community that vote yes. Now, the good news about the chances of this referendum are the last time we voted on this type of issue in 1967, it won. And in fact, it was the most successful referendum in Australia's history. It got just over 90% of the vote. Nothing else even comes close in terms of that level of success. And I'd say to you that if Australia all those decades ago could take out some of the racially discriminatory clauses with a 90% vote, surely we today can get this through by taking the rest of the clauses out of the document. And I find, for example, if I talk on even something like the Alan Jones show or the John Law show, they are horrified to hear, even from that audience, that we still have a clause that is headed races disqualified from voting. It's one of those issues that across the political constituency has very, very strong support for going. It's also the case that people like Tony Abbott are very strongly in favour. And the fact that this debate was generated by John Howard initially in 1999 at the political level is very significant in terms of its ability to get Conservative Australia on side. That's the good news. The bad news is, when you look at referendums more generally, they really are a labour of Hercules in terms of our ability to get them through. We've got some successes, but more broadly, we've had 44 put to the Australian people, but only 8 have passed. And we haven't had any referendum success since 1977. So we're here dealing with the situation where 36 years have passed, more than a third of a century since any referendum was passed. Or to put that another way, if you wanted to find an Australian who had voted yes in a referendum, so at least 18 years of age, you're looking at someone who's 54 or older to find anyone who's actually voted yes. Generations have passed while we've failed to get these referendums through, and a mindset has taken hold that this is impossible, that it can't be done. And that itself is a major, major impediment. In a book I wrote a couple of years ago with co-author David Hume, we, if you like, prepared for this referendum without actually knowing it was going to come on as quickly as it was. We wrote the book called People Power, which looked at Australia's history of referendums. We analysed every referendum to work out what had failed and what actually might enable a referendum to pass, to provide a roadmap, if you like, for this and other referendums. And our major conclusion as to why the record is so bad and what faces us here is simple. That our politicians have an enormous capacity to make exactly the same mistakes time and time again. That you can look at the 36 referendums, and every single referendum displays common characteristics as to why they fail. And I think it's because the referendums are spread out a bit, that they tend to be some years apart, that it's almost as if they started afresh on each occasion and just repeat their mistakes from last time. And in some ways that was quite liberating, because we realised that it's not an overly complicated set of things as to why these things fail, but the single number one problem is a failure of political leadership. and inability to learn from the past, mismanagement, things that are all possible to overcome. On the positive side, we also identified the 4 things you need to do to actually win the referendum. What makes a referendum work? By looking at both the failures and the successes. And look, I'll go through them briefly to give you a sense of what needs to be done to actually give us a chance of getting this referendum up. The first thing you need to do is you've actually got to have bipartisanship. We do need the major political parties on side. We need to recognise that the major parties have effectively a veto in this space. This is one area which explains the majority of failures, and where the Labor Party in particular just likes to bang its head against the same wall over and over again. The Labor Party has put 25 referendums, 24 have failed. So the Labor Party's put a majority of Australia's referendums. That's a 96% failure rate. How many times has Labor got bipartisan support? Once, for the one that succeeded. 24 other times it's gone to the polls knowing the opposition have opposed, and it's failed. And it gives you a pretty clear sense at the starting point of what you need to do. When we talk about bipartisanship here, we're also talking, of course, in a different way in this debate. It's not just about the major parties, but we also need Aboriginal leaders and Aboriginal community strongly on side. It's not enough for this referendum for us to be told by the major parties what it's going to be. I must admit that I'm a person who takes the view that if Aboriginal Australia says they don't want the referendum to pass, then I'll vote against it. I think it's patronising and inappropriate to support a referendum to recognise a group when they actually don't like the wording or aren't prepared to support it. So for me, and I think many Australians, you need the major parties and you also need Aboriginal Australians firmly behind it. That was the main reason the 99 referendum failed on the preamble. The major parties agreed, but the Aboriginal leaders said, you didn't listen to us, we don't like the wording, we want you to vote against it. And many people, understandably, took their lead on that. But at this point, you'd have to say that the signs are good. The fact that we have the major parties in furious agreement, the fact that we have Aboriginal leaders over many years identifying this as an issue of importance from across the political spectrum, that you can get people like Noel Pearson agreeing with Larissa Brent, agreeing with a range of other leaders, that this is something that needs to be done, that the expert panel agreed on the sort of changes that I'm talking about, all gives you a sense that this is in the realm of the possible at the political level. Whether or not we get there really comes down to political management and whether the pressure is strong enough from the grassroots to keep our politicians on track. The second thing we need is, well, we need popular ownership, and in fact, we need bipartisanship, but one of the dangers of bipartisanship is there's a tendency in Australians to say, if the parties disagree, well, we shouldn't do it because one side's getting a leg up over the other. If they both agree, we should even be more worried because they're getting a leg up over us. And there's that healthy tendency to distrust our politicians, particularly when they're in furious agreement. And the only way of overcoming that is ultimately for this referendum not to be driven by our Prime Minister or by our parliamentarians, but by the community. It needs to be owned by the community, the Aboriginal community, the non-Aboriginal community. It needs to be a referendum like in 1967, where our leaders are seen to be responding to the sort of changes that the community would like to see. And that's why groups like ANTAR, Recognise and other groups are so important in this debate. They're absolutely crucial in making sure that the referendum is connected to the community, so that when people go into the polling booth, they have a sense that their peers are actually involved in this, that they're driving the debate. There's not actually the politicians telling us what the politicians think we need. Think only to the most successful mantra from the 99 Republic referendum, vote no to the politician's proposal, the politician's republic. If this becomes a politician's proposal to recognise Aboriginal people, it's lost. So you need bipartisanship, but it's got to be owned by the community, and that takes a lot of time and a lot of effort at the grassroots level. The third thing we need is actually a bit of popular education. One of the most effective ways of defeating a referendum is just say, if you don't know, vote no. In fact, that was the number one argument put in the book in 1999 on the preamble question, the education booklet. The no case just said, if you don't know, stop reading, it's okay, just vote no, it's all you need. And many people, as the polling show, don't have the faintest idea what it's about. They're told to vote no, and that's the safest thing to do. It's quite a reasonable thing to do. If you've got no idea what you're voting on, it's a pretty sensible thing to reject what is being put for fear that it may be a bad outcome. So there's a lot of work that has to be done in getting Australians to the point, not where they're experts, but where they can cast a safe confidence vote, having some awareness of the issue, some understanding of what they're voting on. And that, I must admit, comes from a pretty low base. A survey taken now a couple of decades ago asked Australians, do we even have a written constitution? And 47% said no. And that was actually taken just before the 1988 referendum, before they went into the ballot box. So heaven knows what half of the population thought they were doing in there. But they didn't even know we had a written constitution. So remembering that voting is compulsory for referendums, that's a big, big task. And that's where we've got to move beyond community things to mass media as well, popular culture and the like. It needs to take a grip through the sort of avenues and social media and the like that people commonly consume. Another survey taken just 4 years ago asked Australians, do we have a National Bill of Rights? And 62% said yes. Now that's also an issue because when it comes to this referendum, most Australians will go into the ballot box thinking that the rights of Aboriginal people are already well protected in a Bill of Rights. And I've seen this myself on many occasions when I chaired a process in Victoria that led to the first state Bill of Rights there. Time and time again I ran into people in Victoria and country towns and cities and the like, and they would say, don't support Victoria having a Bill of Rights because we've got the national one. We don't need one in Victoria. And when I asked them what's in the National Bill of Rights, the first thing they'd say is, I know free speech is protected, which it's not. And the second thing they would most often say is, I know in court I can take the fifth. And that gives you a sense again of the challenge here that people are going to consume their information about this referendum from Law and Order, CSI and a range of US cop shows. And it is very, very powerful in terms of shaping Australians' attitudes about their constitution. So it's not just a matter of ignorance, it's a matter of false knowledge which is actually harmful to the chances of the referendum. It's either they don't know we have a constitution, or if they think we do, they think it's got a Bill of Rights in it already. And the most powerful dynamic I find in this whole debate is simply confronting Australians with a provision like Section 25, races disqualified from voting, because it completely upends their perceptions of the sort of protections they think we have in our system of government. And they are frankly shocked. And I've had to go to community events and show them the Constitution because they don't believe me that actually we don't have a Bill of Rights and that we have this clause that enables races to be stopped from voting. And once they see that, they're very passionate supporters for change. They want a system of government that reflects their beliefs and assumptions. And you've just got to educate them about the inconsistency between their beliefs and assumptions in the document that we've already got. Now the fourth and final thing is we need a sound and sensible proposal. We need something that genuinely is safe, that holes can't be picked in, as was the case in the Republic referendums where there really was a major design flaw when it came down to dismissing the President. It's got to be worked over a number of years, and the expert panel report is a really good start. So we're in good shape, if you like, and moving towards that. The question is, can we get the politicians to agree on a sensible proposal, or they want to insert or change it in some way that ends us with perhaps just a symbolic change, which I don't think is sensible, pragmatic, or actually likely to succeed. But Australians will want to know a bit about their proposal and want to know that they can vote with confidence. And that again is a very rational thing to do. The vote that we have likely in 2015 will be a vote that will shape the law in this area not for 5 or 10 years, but for the next 50 to 100 years. That's the lifetime of referendum changes. If you think the last time we did it, 1967, well, that's 46 years. We're looking at it again, probably in about 48 years. So every 50 to 100 years, you might look at these issues. So it makes sense you want to get it right. And it's very important that it's done well. Well, they're the four things. And if you look at the referendums that have passed, they've tended to have some or all of those elements. Of the referendums that have failed, they have in every single occasion lacked one or more of those elements, bipartisanship being the obvious one. So if you do actually end up with a referendum where the major parties support it, it's got some popular ownership, people are aware of the issue and it's been well drafted, it will get up. I mean, that's our referendum history. The question is, can we get there? Can we actually achieve that? And that's the challenge that is facing us over the next 18 months to 2 years. And as I've said, it's something that the community will ultimately get a say on, but the real test of this referendum success is whether the community gets involved now. and actually has a say to give it the best chances of success. So this talk was premised on the question of, well, is it a good idea? Should Aboriginal people be recognised in the Constitution? I won't shock you by suggesting other than my answer is a clear yes. As a constitutional lawyer, I've known for many years that we have a document that needs to be updated, that was actually not only has failed Aboriginal people, but was frankly designed to fail Aboriginal people, designed to exclude them, designed to treat them differently, and to this day that has not been remedied. It's why I'm a passionate believer in the need to have this referendum and to listen to Aboriginal people about the sort of change that they would like to see. I hope that you'll consider getting involved yourself through Recognise or other bodies, and let's hope that this referendum goes to the 4 things it needs to do to actually have a good chance of succeeding. Thank you.
We do have approximately 10 minutes for questions, and if people could also just introduce themselves too before they ask their question. Should we start with Norma?
I'm Auntie Norma Shelley. I'm one of the elders on campus here at UWS. Considering that since our last Aboriginal Concerned One referendum that we've had, we have now got a lot of migrants and coloured migrants here in Australia, more so than we previously had. Do you think that would help sway the vote towards us?
Look, I think it depends on how it's pitched, but one of the reasons that I support putting freedom from racial discrimination in the Constitution is not just because it would advantage Aboriginal people, but that clearly is the case, but I think that clause should be a general freedom for every person in this country, that it doesn't matter what's your background, you shouldn't be discriminated against on the basis of your race. Now that's something that for migrant communities who themselves have suffered discrimination, you would think would be pretty attractive. And when you look at the polling that the expert panel did, in fact that idea of putting in the Constitution the idea that every Australian has this protection actually had even higher levels of support than recognising Aboriginal peoples. Both were high, post-80, so they were strong. But for me, in terms of the strategy, I'd almost be focusing on the idea, let's have a Constitution that treats everyone equally. Let's recognise Aboriginal history, move beyond our past, and have something that's about, a fair go for everyone. That no matter where you come from, we should have a legal system that treats you in that way. And I think that plays to pretty basic Australian values and equally gives us recognition as we should have, but within a framework that works and hopefully unites the whole community.
Good evening, Frida Sanko. You said in the referendum we should get rid of the race power, but we should include a clause recognising that laws could be passed for Aboriginal and Torres Strait Islanders as long as there was no racial discrimination. How would that stop the Northern Territory intervention? Because I'm sure that the government would argue, well, it is for their benefit.
Yeah, and that's a good question. And look, there's no doubt that it would have stopped the intervention in the form it existed in 2007. Because if the Constitution says you can't discriminate on the basis of race, and the intervention legislation says this law does discriminate on the basis of race, and it was there explicitly on the face of the law, and it suspended the Racial Discrimination Act, we've got a problem. But that wouldn't stop the intervention occurring under another name, and I wouldn't want to overstate what a constitution can do. In the end, there'd be nothing to stop non-discriminatory policies being rolled out under the name of the intervention or whatever. It can't cure a lack of consultation, for example, or other problems associated with the intervention. All it would go to is the racially discriminatory element of it. But, that would be a start, I think. But it's why I also see this as one piece in a jigsaw puzzle. And, it's an important part of that in giving protection, but the broader issues around self-determination, I'm a supporter of a treaty, for example, and a range of other things, well, there are other debates that need to be held as well, and they're all parts of the things that need to be done.
There's a question over there.
I'm just interested in this concept of race, but you kind of imply that it almost needs to be removed completely from Constitution. Because when we refer to race, we're using the term incorrectly. We just have ethnic heritage. This whole semantics around race, I come from a multi-ethnic background, as probably do virtually every person sitting in this room, unless you, even if you're maybe Aboriginal and Torres Strait Islander. So it seems we've got quite a bit to do in education. Sorry, my name is Con Kalos. I'm a teacher. We do arts at Coral. And I've been concerned about this for some time.
Yeah, look, I agree with you, and I think, I mean, for me, as I said at the beginning, the education part of it's almost the most important part of it in terms of changing things within our community. And I mean, one of the reasons a referendum is so important is the legal stuff that I've talked about, but actually more importantly, it sets up a national conversation about these issues and changes the way people think about things. I mean, these are defining moments that can be a catalyst in the way things are viewed within our community. And here, it could be a catalyst for proper, overdue recognition for Aboriginal cultures, connections to land, that will open up the education system in a better way. But also I think it could foster a conversation about that concept of race, which is subject to so many misconceptions. And you know, that we can look at the echoes of 1901 and the 1890s still reverberating today. And I can see it in our laws to this current day. How do we deal with that? I think one part of that is something like this referendum, where if we as a community take a stand against discrimination on that ground, that is a very strong statement when you put it in the Constitution that will force a reassessment of these things and will play through the legal system. And you know, it's a generational change. I wouldn't say things change overnight, but I think it's one of the things that could be a positive step towards addressing the sort of things that you're talking about, reinforced within the education system and elsewhere.
Thank you.
There's a question there.
Thank you.
My name is Rhiannon. Hi, sorry, I'm a student. You said and I work with Recognise. I've heard Dr. Anne Toomey talk a fair bit about the Constitution, and she talked about in regards to a clause that would ensure that the government would be able to make laws for the betterment of Indigenous peoples, that the clause should be a purposive power rather than a people's power. I was just wondering what your thoughts were on that.
Yeah, and that's getting to some of the technical drafting, but look, it's a very good question, and it's one of the things that people are going to have to grapple with, I think, over the next year or two. In terms of the tricky areas, which I didn't go into in my talk, one is, well, how do we word this power? We're getting rid of the racist power, so how do we put the new power in and how do we describe it when it comes to enabling laws to be made for native title, sacred sites and the like? And one of the arguments is that we shouldn't describe it as Aboriginal and Torres Strait Islanders. That's one way. But we should say make it a power to pass laws generally for disadvantage, for native title, and put in a range of subjects. And people say the advantage of doing that is that you don't fix upon a group like Aboriginal peoples, you don't seem to single them out in any way. Then instead you look at disadvantage. Generally, look at the jury's out on that. I'm not a big fan of that, just because I think the debate is about recognition of Aboriginal peoples and Torres Strait Islanders, and I think we should be mentioning them explicitly. I don't think we should be concerned about doing that. And also I think in terms of achieving the object, it's the most direct way of doing it. If, for example, you give the Commonwealth power of a disadvantage, well, the states will oppose it, because it will enable the Commonwealth to get into their child protection and all sorts of areas that go way beyond what the referendum's about. You can't have a power for disadvantage in that term, but say it's just for Aboriginal people without mentioning them. That seems to be the problem to me, even though I think it's a useful thing she's saying. I just can't see how it can get us there.
This question from Shelley.
Hi, Dr. Shelley Blefeld from the School of Law. I note that the methodology adopted by the expert panel stated that it was to consider an approach that would be of benefit to and accord with the wishes of Aboriginal and Torres Strait Islander peoples. And yet the proposed section 116A subsection 2 seems likely to allow laws that discriminate against Aboriginal and Torres Strait Islander peoples if they are for the purpose of overcoming disadvantage. So I thought, well, isn't this amendment likely to allow the government to keep enacting legislation that the government perceives to be beneficial for the Aboriginal people, regardless of what those people think of the specific measures? And did the expert panel turn its mind to the issue of where is the safeguard to protect them from their so-called protectors?
Yeah, look, there's some big issues wrapped up in that, and the first thing to say is, of course, the expert panel had Aboriginal people on it, and they signed also Noel Pearson and Marcia Langton and a range of people, so they were happy with that drafting. But what this clause does is it says in Part 1, no law shall discriminate on the basis of race. But Part 2 says, well, you don't discriminate on the basis of race if you're addressing disadvantage or protecting cultural identity and the like. And part of that drafting is my own, in that I helped them with some of that. And the reason for the Part 2 is that if you just stop at Part 1, you can knock out affirmative action laws. So it's actually not directed to enable discrimination against Aboriginal people. It's so that you don't go down the American path of saying, well, a law that says Aboriginal people get entry into university in order to address the lack of numbers, well, that gets knocked out. because you don't have any savings clause to say it's okay to redress disadvantage. That's not racially discriminatory. So that's the object of doing that. More broadly as to how you protect Aboriginal people from their protectors, well, you can put things like the protections I'm talking about, but I wouldn't kid anyone by saying that constitutional change can solve the fundamental problems with our political system. In the end, this is part of that journey, but to be frank, that's why I also support things like treaties and other things that actually get into that area of agreement making. And also, I think ultimately it does come down to issues of self-determination, but they're beyond what this constitution can do. That's up to parliaments to have the right policies. And we may all despair at the moment for the likelihood of that happening. But I would say that an advantage for a referendum is suddenly things look a bit more possible if it gets through. Things that seemed impossible, like treaties and the like, well, maybe if we get a national vote up, people might start reassessing over the longer term whether some of those other important things can be pursued. But look, that's the highest I think I could reasonably put it.
Okay, I think we've reached the end of the time allocated for questions, but there will be an opportunity for more informal discussion
Okay,
later.
take one more if you want. I think there's one more there if you want one more.
Okay, just quickly.
I see a constant running theme through the legal textbooks that I read that Indigenous is actually has, it's not a capital like English, American. I think that's something that needs to be addressed. Secondly, people need to speak up in, like, our teachers, they need to be firm with their stance. They need to really bring it to our attention and push these issues that the media bulwarks from our side. And what do we do as individuals to encourage the media to tell us the truth, to make us aware not of just Indigenous issues, but of issues that surrounding our world that we have absolutely no idea of?
And firstly on the naming issue, and that's a really important one, and this is a really good example of where Aboriginal people need to tell us the answers. If you're recognising Aboriginal peoples, do they want to be described as Indigenous peoples, Aboriginal peoples? And it seems the clear answer at the moment from the National Congress of Australia's First Peoples, the representative body for Aboriginal peoples that's emerged, is it is Aboriginal and Torres Strait Islander peoples. They don't like the word Indigenous, and they're moving away from that, and that's fine. I mean, I'm someone who needs to be told because people have the right, I think, to determine how they are referred to. But that's part of this debate, and it's why Aboriginal people need to lead in key sections so that the words reflect, how they would like to see the Constitution read.
No, what I was referring to is that Indigenous is written with a small I and not a capital I.
Look, and it's one of those things again that I think we need to listen to Aboriginal people to see what they want on those things. I mean, the other point about the media and the like, and getting information on this. I mean, this will get into the media big time when it starts to hot up. And what you hear now is hearing this in the shadow of a big campaign. But this is a really unusual debate in that this can only happen if people vote for it. It can't be run at that top level. If it is, it'll lose. There's no doubt about that. If this is a politician-led thing, it will lose. Now, they know that. The question is, can they just release their grip enough to let the people have a say on this, to help have a say on what the proposal should be, to get involved? And that's also why, I've said a couple of times, you've got bodies like Recognise, Antar and the like. There are forums that people can get involved that are making a difference in this debate, and ultimately it's those sort of bodies that will, be quite crucial in terms of whether this referendum gets up.
Okay, thank you. I'm just going to hand over to the Dean now, Professor Michael Adams, to thank Professor Williams.
Ladies and gentlemen, thank you very much for coming this evening. The School of Law has a 15-year history of social justice, as the university does. When Dr. Murray Wesson, one of our lecturers in constitutional law, came forward and said, this is an important public debate, that we have an interest through constitutional law, it'd be great to have George Williams come to present tonight. I have to say I've known George for quite a long time and was very pleased that it was such an important topic. But these things don't happen in a vacuum. We obviously needed Murray's drive to make it happen. We were very, very grateful to be partnered with the Whitlam Institute and Eric, and obviously the School of Law. But as George was talking, I was thinking our tagline as a university is bringing knowledge to life. And I think formally we should show our recognition by acclamation, because if anything that came out of tonight was that educational aspect, one, the Constitution is an interesting living document. It is interesting that those stats you provided about the surveys, about that lack of information around Bill of Rights and even having a written Constitution, is alarming when you think of going to the ballot box for change. This is a very well-educated audience, and I'm sure we all learnt useful and valuable insights. I'm going to present a small token of our appreciation to George, but show our appreciation by acclamation. Thank you.